Good afternoon, good afternoon, good afternoon. My name is Natasha Robinson, and I am the creator and curator of Legalese Please, a digital platform that talks about deconstructing, demystifying, and decoding legal language. I'm happy to be here with you, although I wish it were under better circumstances. I do apologize for the lateness or the tardiness of my time. I have been on sabbatical, and it has been very, very, very relaxing. So much so that I forgot the login for the platform that I use, which is StreamYard. And so it took a minute for me to get my login credentials. It took a minute for me to set up. Usually I have some type of, what do you call those things? They're lights. I can't remember the the name. But they allow, the reflection and all the professionalism and all that type of stuff. I am completely unedited as it relates to the preparation of this, but I did want to come on because I was tagged and inboxed about what is happening today. And I wasn't going to say anything. I really wasn't, because what can you say? But I did want to come on briefly to provide some legal content and context and to just talk for some of you who may need a space to be able to get out what you're thinking, what you're feeling, the questions that you have, legal or otherwise. We are here for that. What I'm going to do is I'm going to make sure that I am every place that matters, so that everyone can see this this broadcast. So give me just a moment. But if you are here, in fact, please say hello. It's been a while since I've had a Legalese Please episode, and I'm a little rusty, but I am glad to see you, and I hope that you are well. So if you could just say hello so that I know you can hear me, because I don't want to be talking and no one understands what I'm saying because you can't hear. All right, so take a moment. Also, if you would be so kind as to click like, click love, and make sure that you share on your platform so that if there is ever any type of conversation about today, you are able to show this video so that whoever you are in discussion with, they have proper, factual, and actual legal information. So instead of innuendos and emotion, you can engage in a factual discussion that does have evidence and emotion in it. All right. So, good afternoon, Lillian. How you doing? Hi, Tracy. Hey, Nicole. How you doing, Jazzy? Hey, Dr. Peterson. Hey, Carlos. Hey, Ron. All right. So I'm glad that you all can hear me. So let's get into it. Let me give some disclaimers. Okay. Here they are. Disclaimer number one: I did not watch the sentencing hearing on purpose. Until yesterday afternoon, I didn't even realize that the sentencing of Derek Chauvin was upon us. I have had to take a break because we have been through a lot in the last 15 months. And as I call myself a legal commentator, I had to take a break. I had to be able to reconnect with the things that matter. Not that this doesn't matter, but I had to make sure that I was taking care of myself as well as my daughter and my family in the ways that matter. And long after any sentencing occurs, we are still left with the realization of living our own lives. And so I had to take a break. So I did not know until yesterday that the sentencing was today. That's the first thing. The second thing, which is closely related, is I did not watch today's sentencing hearing for a number of reasons. One, for self-care. Two, because I had to get some things done in my house. So I don't know if you can hear, but my washing machine and my dryer is my self-care today because I'm cleaning, and it has been very relaxing. Three, I have been part of sentencing hearings for the 12 and a half years that I was with the Public Defender's Office of Cook County. So I'm very familiar, even though Derek Chauvin's sentencing occurred in the state of Minnesota. Uh, there are a lot of similarities. And I have had my share of sentencing hearings, so I already knew what was going to occur. So I didn't need to watch that. And then the last reason I did not watch the sentencing hearing is because I knew I was going to be pissed. I knew I was going to be angry. And sometimes that anger can come and fly in the face of the analysis. And so I knew that I was not going to be able to watch the sentencing hearing without getting ticked off. And from what I have been notified with or notified about as relates to what was said and what was not said, I knew that the mother of Derek Chauvin was going to tick me off. I knew that. And from what I have read, I did the right thing by missing it. Because I don't understand how, I can understand how a mother can make it about herself. But her saying that she can't hug her son anymore, I'll just try and keep this cuss free. Yeah, you think? You're not the only one who will be unable to hug their son, their father, their cousin, their nephew. And yeah. The other thing is I have been in the defense spot, not necessarily representing someone who has killed a person and they were a police officer. But I have been in the situation of mounting defenses and calling witnesses to try and show factors of mitigation as to why my client should not be punished to the fullest extent of the law. All right. So, from what I understand, on the date in which Derek Chauvin was found guilty, he was found guilty of 3 counts. He was found guilty of second-degree unintentional murder, third-degree murder, and second-degree manslaughter. And he was sentenced today, and he was sentenced to 22 and a half years in prison. Now, the way that is broken down is the following. According to my research and what I have understood, he has already served 199 days in jail awaiting this trial. So that time is going to be taken off of the 22 and a half. The other thing that I am to understand is that in Minnesota, the expectation or the protocol is that when a person is sentenced, they are looking at 15 years. And then afterwards, there's a determination as to whether, because of good behavior, that person is then put on parole. So if in fact he only has to serve 15 years, that does not mean that the 22 falls away. What that means is the remainder of that 22 he serves on parole, or what can also be called supervised release, but we know it as parole. So, and I put something about this on my Facebook page so that you're able to understand. But according to what I understand, and I'm going to read this quote that comes from an NPR article. Quote, under Minnesota law, people sentenced to prison become let me start again. Quote, under Minnesota law, people sentenced to prison become eligible to be considered for parole after serving 2/3 of their sentence, as long as they've had no disciplinary problems while in custody, end quote. So what does that mean for Derek Chauvin? It means 2/3 of 22 and a half years would put his sentence at 15 years, minus the 199 days he's been in custody, which is called time considered served. And so what would happen is 2/3 of 22 and a half years put him at almost 15 years. It's really 14 point, I think, 85. And then you subtract from the 22 also the days that he's been in custody. And then that time, assuming that he is in no type of legal trouble, would then be served on parole. So that's where we get the 15 years. Now, question, will he have to face federal time as well? Okay, so, oh, and I did not ask because I told you I'm rusty, is that if you have any questions, please make sure to put them in the chat and I will try to answer them as well. Okay. So let me answer this question. Will he have to face federal time as well? It depends. According to my research, and this is research that is open for you as well, is that when I looked up his federal case, what he is going to be indicted with, along with the other 3 police officers, is violation of civil rights, which means that the prosecution has to prove that he, Derek Chauvin, acted under the color of law and violated George Floyd's constitutional rights. Okay. He does not appear in court for that federal offense until I believe it's September. If he is convicted in the federal case, any federal sentence that he serves will be at the same time as his state sentence. Because also, here's the other disclaimer, because I do not practice federal law or civil rights law, you would have to then defer to that analysis from other attorneys. Now, one attorney who I know who is good in that, or 2, I should say, who happen to be my friends, are attorney April Prayer, who, if you go to her page, Just Us Junkies, JUSTUS, and then JUNKIE. She is excellent in breaking down charges involving civil rights and police officers. My second friend is Aaron Goldstein, who, although he is the chief of the Child Protection Division in Cook County Public Defender's Office, prior to that, he was in private practice, and he is also another excellent source of information. So I defer to them. I know they're like, wait a minute, we're not on your live. It doesn't matter, because when you have good friends and even better colleagues, they are able to have a situation almost like when you're running a relay race and you pass the baton to somebody else. I am passing the baton to them because that is not my area of expertise. Okay, so he is going to face federal charges. In terms of what the prosecutors have to prove, prosecutors, they have to believe an officer acted under the color of law, which is called government authority, and that they willfully or on purpose deprived someone of their constitutional rights. All right. So they have to prove, in short, that what the officers were doing, they knew was wrong, and they did it anyway. Now, does that sound easy to prove? Absolutely. Is it easy to prove? Absolutely not. All right. And so the prosecutors, they definitely have some big goals to meet. Is it impossible? Absolutely not. But understand that they're trying to wait for the state to finish their side before the feds start. The other thing that you need to know in terms of sentencing is that I'm trying to look at your comments. The other thing that you need to know about sentencing, and this is where I wish I kind of knew someone who worked at CNN, because I could text them Um, it is not breaking news that Derek Chauvin asked for a new trial. That is the legal protocol by which the defense attorney is supposed to respond. Please understand, if you remember, which you probably don't, but that's fine. If you remember the last time I was with you all, I told you that the defense has to set in motion different things for which they want to appeal later. And so the defense attorney, whether we as a public agree or not, has to protect the rights of his client and has to preserve issues for appeal. So the defense attorney has to keep requesting for a new trial, because when, not if, but when they appeal this conviction and this sentence, they have to be able to say, we argued for this sentence to be overturned or for us to get a new trial at the trial level. Because if they don't do it at the trial level, then at the appellate level, if the case is heard, they lose that right, because you have to say it first at this level before you get to the appellate level. Okay, so the defense attorney asking for a new trial is not because Derek Chauvin deserves a new trial automatically. It just means that the defense attorney is doing the defense attorney's job, whether we agree with it or not. All right, are we clear on that? And if I have not said it already, you can hit like, love, share, so that when you get into conversations with others on social media, because at this point, if you notice, there is an influx of people who have gotten their law degree. Because I tell you, everyone is going to have a position, and sometimes those positions are going to be incorrectly rooted in law. Okay, so make sure you are not just having conversations that mean nothing, and also make sure that you are protecting your peace. So if you did not watch the sentencing hearing, or if you want to have nothing to do with any information as it relates to this case because you saw enough or you heard enough in the murder of George Floyd, I completely get it. I completely get it. But I did want to come on and just give you these little tidbits about what happened today and where we go from here. So where do we go from here? On the state level, as I said earlier, the defense attorney is going to ask for a new trial. The defense attorney is then going to file what are called appellate motions. And in that appellate motion, they are going to appeal to the Minnesota Court of Appeals. And they're going to say what the trial judge did and what the jury did was illegal, or it was unfounded, or they did the wrong thing. And then the Minnesota Court of Appeals decides if they're going to hear the case. If they're going to hear the case, they can hear arguments from defense counsel, arguments from prosecution, and then decide whether or not they are going to sustain the motion, which means that they are going to agree with the defense attorney. If they're going to sustain, they can overrule it and say, no, we're going to agree with what was done with the trial level. Or sometimes they could say, you know what, we're going to send it back to the trial court in order for him to get a new trial or for him to get a new sentence. All right, so those are possibilities. Let's see. Hey, Sora, how you doing? You are always welcome. Second question. If he gets an appeal, will his sentencing change in terms of the numbers of years? Yeah, I just explained that. But you may have typed that before I explained it. So the appeal, let's understand, the right to appeal is guaranteed if you do it. The right to be heard is something different. So just because it appeals does not mean that the Court of Appeals has to listen to that case. Okay, that is their discretion. They can decide whether or not they want to hear it. And if they do hear it, they will review not just the transcripts, what has happened in court, they will also review everything that has happened from the moment Derek Chauvin was charged. And then they will decide whether or not, if they decide, when I say they, I mean the Minnesota Court of Appeals. If the court decides to listen to the appeal, They will look at all of the transcript, everything that has been filed, and they will take into consideration both sides before deciding what they're going to do with it. Okay. So will his sentencing change? Possibly. We don't know. We won't know until the Minnesota Court of Appeals issue a decision of yes, we're going to hear the case, or no, we're not. But what's going to happen is this appeal does not stop his sentence. Okay. He will continue to serve his sentence while any appeals is going on. Unless the appeals say, okay, there's something so egregious that happens that you need to yank him out of custody and make him a free man while this appeal is going. The likelihood of that happening is -9. Okay. He is still going to be serving his sentence, I'm pretty sure, while the case is going on. The other thing is, remember, he still has a federal case. So even though he will be looking at a federal case, he will still be serving state time. Okay. So I don't know if his sentencing is going to change, but right now it's at 22 and a half. Okay. Next question. How many times can an appeal be made? Once. And when I say once, what I mean is once the Minnesota Court of Appeals, if they say we're not going to hear it or we've heard it and we're going to stand with the trial court, the defense attorney is not going to then come back and say, oh, by the way, we forgot something. It has to be in that situation. It has to be based upon, I think the standard is new evidence, which there is something that is existing that we have never seen before. And the defense attorney comes in and says, you know what? That in fact was not Derek Chauvin who did this. It was actually something. It has to be something so ridiculous, so out of the order of what we've already seen. So this is why you keep hearing the repetitiveness, if that's the word, the repetitiveness of the defense attorney. He is making sure that there is nothing that will not be included in the appeal. He is making sure he is able to say, okay, I said I objected to this, I objected to this, I objected to this, I objected to this. And so he's not just, I mean, he could be doing it to be an ass, but I'm giving him the benefit of a doubt that he is doing it to preserve his client's appellate rights. Because you can't come back usually after the fact and then say, oh, I forgot something. By that time, the wheels have been going on. Okay. So I hope that made sense. Okay. So that is pretty much all that I have. Okay. Wait, there's another question. I think the question is, who hears the federal case? The federal court in which he is assigned. He is assigned to, let's see, I'm trying to find out where he is assigned. Because I just told you, this is not my area of specialty. Federal. I am state. I remember reading something about where he is supposed to be in federal court. Okay, so far he's appeared in front of U.S. Magistrate Judge Becky Thorson. Okay, where her courtroom is located, I don't know. That would be your homework. It's trying to find out where she's located. I know that when you hear federal, sometimes we automatically think, okay, now that person has to go to DC. That is not true. There are federal courtrooms and courthouses in different states. For example, in Chicago, you have state courts, which you can see in different counties of Illinois. In Cook County, where I reside, there is a state court, different state courts at 26th in California, at 54th and Wentworth, just different places around the county. But there is also a federal court that is downtown. It is on Dearborn. This is where I have taken some students in the past, and you have a federal courthouse there as well. Okay, so it's the same thing in Minnesota. You not only have state courts, but you have federal courts as well. And so my gut is telling me that he's still in Minnesota. He is just going to federal court there uh, instead of just state court. All right, you don't have to apologize. I just want to put those disclaimer out there so that you all have your expectations met. So you understand that sometimes law is not the same as medicine. You know how in medicine you have different specialists, and they specialize in, say, podiatry. They specialize in pediatrics. But generally speaking, every doctor has done, the type of foundational understanding where they can say, okay, this is not my area of specialties, of expertise rather, but I can tell you need to do such, such, so. Law's a little bit differently. You can go through law school, never declare a major. You just take the foundational courses, and then you decide what you want to specialize in, either because that's your desire or because that's where the job is. And so that's why you will have lawyers where someone will inbox me or text me and say, hey, I have a employer-employee case, and I want to sue my employer for wrongful termination. What do you think I should do? And then I would be like, I think you should find a lawyer. And they think I'm, being I don't know, being offensive. I'm not. I'm saying that you need to find someone that specializes in that area. I do not specialize in any area, but when I did specialize, it was in state level criminal cases, particularly criminal defense. So that's why I say that my comments, take them in the context that I provide them, but you can always do your extra research by looking online and then seeing what reputable, bold, underlined, italicized, reputable news sources and legal sources have to say online. All right, next question. Do you feel that the judge sentenced him the max amount that he could regarding the charges he was facing? Well, the max amount is 40 years for the most serious offense. So do I think he sentenced him to the max? Of course not. Do I think he went as high as he could have, considering this is a judge who is sentencing a police officer? I mean, yeah. The reason why I'm hesitating is because there are so many factors that go into the sentencing of a person who has been found guilty. So could the judge have gone higher? Absolutely. The judge could have gone and asked for the max, because remember, the prosecutors, the attorneys who brought the criminal charges in this case, they wanted the judge to go to 30 years. Okay. The defense attorneys wanted, naively, to get probation and time served. At least that was at the very beginning. I don't know what they wanted now, but I read that the defense attorney was like, hey, he didn't mean to kill him, and just give him probation because he doesn't have a background, and give him time considered served. So basically, you are arguing for your client who killed someone in daylight in the midst of a crowd while being a police officer. You want them to serve 199 days for taking a life? I mean, the truth be told, there is no adequate sentence to me that can make up for, substitute for, be equated with justice for what was done to George Floyd. There is no sentence, there is no punishment, there is no fine that is able to adequately and explicitly state that this cannot happen again. There is nothing, in my opinion. And so being asked to sentence Derek Chauvin to 30 years, the possibility being 40, and he getting 22 and a half. If we know anything from what's that man's name that killed Laquan McDonald? If we know anything from that case, what we know is that you can hear one thing, but you got to calculate it in real time. Okay, so don't ever be concerned with the numbers. Be concerned with what is the outcome after you do all of the subtraction and division and all of that type of stuff. Okay, Dr. Peterson, at the end of the sentencing, the judge said the lesser two charges remain unadjudicated. Can you talk a little bit about that? Okay, so I don't know what he meant by that because I did not watch the sentencing hearing. But what I understand is that whatever the major charge is that he is being sentenced to, the remaining two charges are they're collapsed into that. So all three in which he was found guilty of are collapsed into one in terms of punishment. Now, I don't believe that the judge dismissed the other two charges because the jury found Derek Chauvin guilty of all three. My understanding is that whatever the major charge is, the other two are collapsed into that third. So it's all three into one. I hope that makes sense. And I hope I'm not mischaracterizing what the judge said, because unadjudicated means untried. And so I hope the judge did not make a mistake in that, because in fact they were tried. All three charges were tried, and Derek Chauvin was found guilty by the jury on all three. All right, do you all have any other questions? I hope you click like, love, share on your social media platforms. How are you feeling? That is the second part of this broadcast. How are you feeling? What do you think? Because there is space for that. There is space for that here. You are welcome. You are welcome. How are you feeling? I'm just being quiet because I'm reading your comments. Dr. Tracy, you says not the best. That I sit with you on that. As I said at the beginning of this broadcast, I did not watch the sentencing hearing on purpose because I've seen this too many times. I've seen this too many times. I'm explaining it good because, that is the whole purpose, of Legalese Please, is to break it down so that we not feel intimidated or disenfranchised by all of the legal jargon. And we feel like we can be in a space where if there is any confusion or any misunderstanding, that there is no shame attached with that. Because, if you put two lawyers together or two doctors together or two teachers together or two business workers together and they are talking what's called shop, if you are a person who is not equipped with that language, then you could feel disqualified because you're hearing this, but you're not understanding. And so that's what Legalese Please is designed to do, is to make sure not only that we hear what is being said, but we talk about what is being said. And I want to make sure that no one walks away with even more misunderstanding. Okay, so that's why we're here. Ron says, I'm okay with the sentence because I was not expecting to get the maximum. Be clear, me neither, because I have seen this too many times. And the former officer that killed Laquan McDonald, it just hit me, Jason Van Dyke. You remember when the judge said that Jason Van Dyke was sentenced to, I think it was 80 something months, and everyone was cheering. And meanwhile, we over here at Legalese Please was saying, okay, well, there are 12 months in a year. So 88 divided by 12 is 6 years. Okay, which is why it sounded great when you heard 88 or 80 something months. But when you do the math and a calculation, you'd be like, that ain't no time. Okay. And then you also have to take into consideration what type of sentencing the person is getting. In Illinois, there are certain charges where you get 50%, where you have to serve 50% of the time. And then there are other charges you have to serve 85% of the time. Okay. And then there are other charges you have to serve 100. And so you have to take all of that into consideration. But if you do not practice that type of law, you may not know that. And you not knowing that is not your fault, which is why we are here. All right. So I see some more comments. Carlin, he said because they were lesser charges and the sentencing would be lower than the first charge, he wasn't going to rule on them. Okay. Well, thank you for sharing that. My response to what he says is it don't matter because the defendant, who was Derek Chauvin, was convicted of that. But usually what happens is that the times are consolidated into one. So, you know, I think it's a play on semantics. Dr. Tracy, hard to explain to eighth graders about the justice system and how it's not always just. Absolutely. It's hard to explain to grown folks about the criminal justice system. So if if you need any assistance or something like that, you know how to contact me. I will be happy to help you with that because there are a lot of nuances with that. And we have to be able to discuss it in ways that they might not make sense, but the babies comprehend it. Okay. All right. Derek Wolper, feeling emptiness. Agree that no sentence brings justice. George Floyd should be alive. That's justice. Glad he got at least a decent amount of time. Yeah. And as you know, Daniel, from what we have seen, decent amount of time is relative. It is relative. MD Black, it feels as though it's a slap on the wrist. Other officers will continue to take things into their own cockiness until they are caught on cameras. So you say a lot in that statement, and let me go as I am being led to answer. The first thing is I am big on understanding how discretion can be a tool and a weapon. We like discretion because if used as a tool, then law enforcement, who I would say are the first gatekeepers into the criminal justice system, they get to decide whether or not a person is going to enter it or stay out of it. So discretion as a tool is police officers saying, okay, here is a warning for you speeding. Here is a warning for you having, a little bag of weed or something. Here is a warning for you, young person, to make sure that you speak to us and this does not happen anymore. That is discretion as a tool. Discretion as a tool for prosecutors is deciding what charges, if any, to bring, or prosecutors standing in their courage and saying, you know what, there's not enough evidence to charge this person. Or discretion is going into different rooms in courtrooms and the prosecutor saying, in exchange for you going to theft deterrent school, you going to drug treatment, you going to a mental health facility, we will not charge you or we will not prosecute. That is discretion as a tool. Discretion as a weapon is what we fight against, where officers, law enforcement, prosecutors, even defense attorneys and judges will use their discretion, their bounds in the law to weaponize their prejudice, their bias, their racism. That's what we fight against. And so this is what Derek Chauvin did. Derek Chauvin is not a police officer who happens to be racist. Derek Chauvin is a racist who happens to be a police officer. Okay. So if he was a chef, if he was a taxi cab driver, if he was a teacher, his racism would still be manifest in what he does every day. So, MD, when you're talking about cameras, also understand that just because, and I'm not saying it to you, I'm just saying it in general, just because something is caught on camera does not mean that that person is going to be held accountable. Okay. Think about Eric Garner, where you had evidence from different perspectives, and which the New York jury who was convened, the grand jury, said that there was no evidence to show that the officers killed Eric Gardner by a chokehold, which was it was prohibited against by the New York Police Department. Okay, so even if we have cameras or even if we have evidence, that does not mean, one, that the police officers can be held accountable, and then two, it does not mean that factual evidence is equivocated with legal evidence. Because even with cameras, even with videos, there still has to be rules of evidence that has to be met. And if those rules of evidence have not been met, and if someone's rules have their rights have been violated, then even if you have film, that does not mean that that can automatically go into evidence, because if that video evidence was acquired through the violation of somebody's rights, then under the Supreme Court case of Mapp v. Ohio, that rule, or that state's exclusionary rule, that evidence cannot be used against the defendant. Okay, so should we still be diligent? Absolutely. Should we still use video evidence if at all possible? Absolutely. And I'm glad that this was filmed in the sense that it did show what has been happening all of the time. But what do we do in those situations where there is no video evidence? How do we get justice? And I don't have an answer for that. Okay. Carla says, no, I'm happy he got something to wear that no amount of time would be sufficient. His loved ones are serving a life sentence without him. Absolutely. Ron, I also learned from you there's a calculation method to sentencing when certain factors have to fit. It's not cut and dry. Absolutely. And you always have to defer to the state's sentencing guidelines, which, some judges can't just be out here. Well, actually, all judges cannot just be out here giving sentences. They have to follow the law. And this is where I say a lot of times we expect the courts to be the first and last stop on our way to justice. Okay, that is not the case. When we have different elections, those are the persons who make the laws that the judges and the prosecutors and the defense attorneys have to follow. Okay, so there cannot be any maximum for a case if the lawmakers haven't first decided it. Okay, so for instance, let's take the state of Illinois. State of Illinois, the lawmakers on the state level are in the General Assembly in Springfield. All right, they are the ones who make the criminal code. All right, you have in the city of Chicago, you have the alder persons, you may have the mayor, you may have in the state of Illinois the governor by way of executive orders or referenda or things of that nature. But for the most part, it's our lawmakers. So if you have a person who says, well, I'm not going to the poll to vote because it's just us deciding local leaders, or it's just us deciding state leaders, I'm waiting to the presidential election. This is why shit gets passed and you don't know about it until those laws are enacted against you or your loved ones. So we have to be vigilant at every level. Every ballot matters. Every voting cycle matters. I'm talking about politicians. I'm talking about mayors. I'm talking about governors. I'm talking about judges. Okay. Where you want to know, well, how did this judge get on this bench? Well, if no one is saying what this judge is doing that is illegal or unethical, then you are like, so I have a couple family members, when they walked into the ballot box, they would just say, okay, well, I'm just going to check this person and I'm going to skip it. I'm going to check this person. I'm going to skip that. That is not voting. That is selection. Okay. Don't let your vote just go to the side. All right. We have too much power and we need to be informed in our power. All right. So I have been on here for almost 45 minutes. That was 15 minutes longer than I had anticipated, but I wanted to make sure that I was asking you, the audience, how you were feeling, and also to answer any questions that you have. All right. So hopefully This has been informative. I thank you for watching. Please click like, click share on your social media platforms. If you have any questions that you cannot think of now, that you think of later, then just put it in the chat for this broadcast, and I will be happy to answer it. Okay. Thank you all so much for coming. Legalese Please, by way of information, is going to be on sabbatical until September. All right. So you will not hear from me unless and until it is something that I just cannot sit on and I need to discuss with you. But I am going back to my sabbatical. And I pray that you are well, that you take good care of yourself, and that you just stay empowered as best you can. All right. Thank you, Dr. Peterson. I appreciate you. MD Black, it's my pleasure. Hey, Fred, how you doing? Hey, Ronaldo. I'm glad that you all are here. Okay, with that, you take care. Have a great week. Bye-bye.